This is the second lecture of the series on alimony. We're going to talk now about some of the historical background of alimony. Alimony in the early days was a very important legal concept to women because of the need for support. This comes from the idea, as we learned in Chapter 1, that back in time, women did not have control over their property, and they weren't even allowed to own property. Up until 1946, in fact, the Florida Constitution didn't provide for the property rights of women. So obviously, alimony was vitally important, because upon divorce, women had no means of support, and for many years did not have any means because they were of sole support because of their inability to own property and other things. Also, remember that long ago, and still today of course, but it was more common for a woman to be running the household and not working outside of the home. Many women of that era are still living, by the way, and so you may even find that one is divorcing here and there in the practice where you work. A couple of places in this lecture you'll find also that as a result of the changes to the societal constructs and values about women, you'll find that the legislation about alimony has changed the laws of alimony in Florida over time. And some of the changes were as recent as 2008. Fault grounds play a role in the alimony discussion. Fault grounds for divorce have had some effect on the changes to divorce laws as well. So not just the history of society changes, but also updates to the law enacted to, for example, place less social stigma on divorce. Listed on this slide are some of the traditional fault-based grounds for a divorce. Unfortunately, fault-based grounds also promoted standards regarding alimony that resulted in a punishment factor of the offending person. For example, if adultery was proven by a husband, the wife lost both alimony rights and rights to any marital property. Collusion was also possible under the fault-based laws because couples who were merely unhappy with their marriage and wanted a divorce had to stage adultery, for example, in order to be given a divorce. No-fault grounds are the norm today. No-fault grounds have become the basis for dissolution, and we now have grounds such as irreconcilable differences, incompatibility, and irretrievable breakdown. These now are the standard grounds for divorce. Again, if one party wants a divorce, the only proof needed is someone saying, "I don't want to be in this marriage any longer," or "I can't resolve the differences, we're irretrievably broken." This change in the legal grounds for divorce also changed alimony a lot, the laws of alimony. Marriage, though, has now been more regarded as a partnership than it was historically. Today, the alimony laws have changed as a result of this look to the partnership model. Women's rights have resulted in women becoming more economically self-sufficient. A business partnership model began to be considered in determining marital assets as well as alimony. But alimony seemed incompatible with this partnership model. In other words, alimony, in terms of the prior fault-based model of alimony, is presently incompatible with a partnership analysis. And this is mostly because both husband and wife are often working today, and even if they're both not working, or even if they're not both working, they are providing together for a family as part of the partnership model. The case of Orr versus Orr is discussed in the textbook, and it is one that I think actually stemmed from Florida. And it's a United States Supreme Court case, which means it's a federal question that ended up in the United States Supreme Court. Also historically, and this is a 1979 case, so that wasn't that long ago, but historically, alimony statutes could be gender specific, meaning the laws allowing for alimony tended to be worded to help women get alimony and not men. This case of Orr versus Orr from 1979 is important because it looked at the gender-specific nature of some statutes about alimony. Today's laws provide that either a man or a woman may have a duty to support a spouse. And one of the reasons why is because of this case of Orr versus Orr. The duty of alimony, or support that is, may stem from several life factors such as reduction of career opportunities, illness or disability, long-term marriage, and the resulting standard of living enjoyed during the marriage. And these things can happen to either the husband or the wife. I should also point out, if you decide to read this case in the book, that the publisher has mistakenly referred to attorney's fees instead of alimony. And I got lost, and I looked at the case online or in Westlaw Next, I'm not sure which, and I realized that that was a typographical error, that it should be alimony, not attorney's fees, that the publisher uses. In any case, the Orr case does not address at all the constitutionality of a statute on attorney fees. More on alimony reform. There have been many reforms to limit alimony awards. In fact, Florida's legislature in 2012 and 2013 would have eliminated what we call permanent alimony. And I'm going to explain on another slide what permanent alimony means. In addition, some legislatures have even looked to changing alimony so that there is more of a rigid mathematical formula like that we use for calculating child support, where the formula is based on income of the parties and a few other financial things. These things have been attempted to, these types of legislation have been brought forth to try to limit alimony, and Lupino and Miller in their textbook do talk about some of these legislative activities. But there are some historical factors about alimony also included in Keene's book in the chapter about alimony. I also recommend the other readings on the last slide of the introductory lecture of this series, because there's a journal article from the Florida Bar by the authors Larkin and Kay, and that is a good article about Florida alimony and the history of it. In 2013, the Florida bill that I mentioned earlier was vetoed by the governor because of the lack of clarity and concreteness of the bill's language. And many other limitations have been enacted in some states, some similar to what that bill in Florida tried to change. For example, we look to the contributions of the payer spouse, the contributions of the payer spouse's new spouse or cohabitant's income. What I'm saying here is that the payer of alimony would end up maybe being considered to have more income if that payer had a cohabitant or a soon-to-be spouse at the time that the divorce is being granted and alimony is being calculated or decided on. And so keep in mind, in that regard, alimony awards are made by the court hearing the case at that time, and the decision is based on those circumstances of that time. And judges don't look to the future when making alimony awards. Oftentimes, upon divorcing, a person who is a potential payer of alimony might have already begun cohabitating with someone such as another partner. And we can look to the income and resources under the present circumstances at the time of the divorce. And this is what the Florida statutes require. So in favor of those persons who are leaving a marriage and at the same time entering into a new partnership with someone by cohabitation, for example. People have asked the legislature that not be considered, that new partner's income not be considered in determining how much income the potential payer of alimony has at the time of divorce. The courts in Florida also, in addition to, this concept of how much money the payer has, the income coming into the payer, goes to the ability to pay standard. That's important to the Florida threshold. It's of threshold importance to the Florida law in determining alimony. The courts in Florida look to the need of the person seeking alimony. And so those two questions, need and ability to pay, are the threshold legal questions. And if a person who is receiving financial support from a partner prior to divorce, it's presumed that they have less need. So the point I'm trying to make is the problem of cohabitation at the time of a dissolution of marriage can have adverse effects on either party. The payer might have a partner and therefore more income and financial ability to pay, and the receiver, who's the potential receiver, the person seeking to get alimony, might be foreclosed from alimony because of that relationship. So these are important to understand, that it can be favorable or unfavorable depending on which side you're on, the payer or the receiver. This concludes the second of the series of alimony history. And so you'll move on to the next in the series, which is lecture number 3.